Did the Commission on Forensic Sciences unconstitutionally allow familial DNA search? To find out, you have to read Stevens versus DCJS, but it's 53 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of Stevens versus DCJS, published by the New York Court of Appeals on October 24th of 2023. The citation for this case is 2023 New York Slip Opinion 05351. And the issue in this case is whether the Commission on Forensic Sciences has the authority, the authority to authorize familial DNA searches, or whether that's an unconstitutional overreach by an administrative agency. To appreciate the context of this case, I think there's a couple things that are best understood. First is that using DNA in criminal prosecutions is relatively new. The first time DNA was used for criminal prosecution was like the 1980s. And in 1994, the DNA Databank Act was passed by the New York State Legislature, which did several things. It created the Commission on Forensic Science, the DNA Subcommittee, and the DNA Databank. The DNA Subcommittee is a group of exclusively scientists, and their job is to advise the Commission on Forensic Sciences about accreditation, best practices, the reliability of DNA analyses. Then there's the New York State Commission on Forensic Science, and they're a group of mostly non-scientists, and their job is to make policy for the establishment and operation of the DNA Databank and release of DNA information with regard to matches. And lastly, the DNA Databank itself is a repository. It holds thousands and thousands of, at this point, dozens of thousands of DNA samples and DNA identification information from people who've been convicted of different crimes. Because part of what the law has now required is that if you're convicted of certain specified offenses, you must give your DNA sample to the system, and they put it into this DNA Databank so that if you wind up committing, well, we'll get there in a second. Beyond creating the three institutions above, it authorized the Commission to develop regulations about storage of genetic information and the use of the databank, including when to release the identity of a match. That's the word they used, a match, in response to law enforcement requests to access the databank. What kind of matches are there? There's three kinds. There's a direct match, a partial match, and a familial DNA search. A direct match is when, let's take an example here. Someone commits a burglary and they break in a window and they steal all the stuff and they get away and no one ever sees them. But they get cut by the glass that's left behind and there's blood on the glass. Investigators will come find that blood, take a sample of it, and submit it for analysis. It gets compared to the DNA Databank. If the specific alleles on the sample of blood match the specific alleles on the same positions, the same loci, means the places on the part of the DNA that they search for, and they match, exactly match, then if it's an exact match, it's called a direct match. And then the DNA Databank will inform the law enforcement agency, well, we know whose sample that was. That sample belongs to John Smith in the databank because he'd been previously convicted of a crime and we have his DNA. They then use that information to further the prosecution. Apart from a direct match is something called a partial match. A partial match is a near hit. A partial match results when someone's trying to do a direct match. They submit it to the system, but instead of finding 100% of the same alleles in the same places, maybe they find 95% of the same alleles in the same places. Why? It could be a number of reasons. It could be a degraded sample. Maybe the blood is too old. Maybe there's multiple sources of information on the blood, or it could be a close relative of the actual of the source. It's a result of a failed attempt to get a direct hit. And lastly, there's a familial DNA search, and that's the intentional searching for relatives of the people in the DNA Databank. The last thing you have to understand to appreciate this case is that Article 5, Section 3 of the New York State Constitution allows the legislature to assign, by law, new powers and functions to commissions. They can delegate responsibility of policy making to some extent to commissions as long as they've specifically restricted and guided the use of that authority. But it cannot pass its law-making functions to other bodies. So commissions can help the legislature, but it can't supplant or replace the legislature. Okay. So what are the facts here? The facts are that, as we said, in 1994, they passed the DNA Databank. and it only allowed for direct match to be released. In 2010, the commission expanded that to a partial match. So now, if there's a partial match, they will inform law enforcement. But in 2017, the commission expanded it to authorize familial DNA searches, which means that people who have never committed an offense, have never been convicted of a crime, and whose DNA is not in the system can now be identified if they have family members who are in the system. So in this case, the two plaintiffs, Terrence Stevens and Benjamin Joseph, are two black men living in New York who have never been convicted of a crime, and their DNA is not in the DNA Databank, but each of them has a brother who was convicted of a felony. And so their brother's DNA is in the databank. They sue the agency, they sue DCJS, claiming that the familial DNA search is an unauthorized statute that exceeds the DCJS's authority to issue and therefore violates the separation of powers under that section of the Constitution I mentioned before. DCJS denied the allegations and said further that they lack standing to sue. The procedural history here is that the trial court held that they had standing, but denied the petition on the merits, said that this was not an unauthorized exceeding the authority, and upheld the rule. The appellate division reversed, granting the petition, and annulled the regulations, and now it goes to the Court of Appeals. And here, there's two questions that have to be answered. First, is there standing? And the second question is does this exceed the authority? Standing is a question of whether the particular plaintiffs in this case have an injury in fact, and whether the issue that they're addressing is one that's in a zone of protected interest. But the big question here is, are these people who have never been, who are not right now under investigation, they're not claiming that their DNA was linked to a specific crime. They're saying, while we're not victims of the DNA search yet, we are likely to become victims of it, or we are in a class that's likely to become victims of it, because although our DNA is not in the system, our brother, each of them have a brother who's in the system. So if they are the most likely out of anybody who's not himself identified by a DNA match to be identified. They are amongst the class. So the Court of Appeals says, yes, there is standing here. They say, while they're not victims of the DNA search, the court should not strictly apply the standing rules in such a restrictive way as to avoid completely shield an action from judicial review. They said they have a unique risk of being identified through the databank and targeted for police scrutiny due to familiar relationships and shared genetic material. And yes, the Databank Act seeks to limit the number of people that are exposed to DNA searches, and so this is the zone of protected interest. But the bigger question here is whether this is exceeding the authority, whether this violates the Constitution of New York State by expanding this to not people who've been convicted of crimes, people whose DNA is in the bank, but people who are innocent of crimes, who've never committed any crime, never been convicted of anything, being identified via the DNA Databank. And as to that question, they say there's only two questions. Does the legislature have the power to delegate rulemaking over familial DNA searches? And did they do so? And here they say everyone agrees the legislature has the authority to do it, and they did do it. They authorized the commission to have access to the databank and to define what a match is. And all they did here was expand the definition of match. There's a direct match, there's a partial match, and now there's a familial match. So the majority says this is not a violation of the Constitution. There's a very strongly worded dissent here. This is a 4-3 case again. And the three dissenters say that this is a violation. They apply a different test called the Boreale test, which basically says that this is an overreach, and basically they're doing what the legislature was unable to pass, although they tried to do it many times. And so it's actually, you're specifically allowing people to be identified who have not been convicted of a crime, and this violates the separation of powers, according to the dissent. And that's the case of Stevens versus DCJS. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.